The fluorescent lights hummed above the courtroom as the judge took her seat, her tone sharp and commanding. "My salary is paid by the taxpayers," she began, her eyes sweeping the room. "And guess what? If we need to be here on Saturday, I know nobody has anything to do. I will be here on Saturday, so we're going to get it done." The defense table fell silent. Papers shuffled nervously. Across the room, the prosecutor straightened his jacket, quietly waiting for the storm to pass. Defense attorney Jason Goss rose from his chair. "Judge, if I may, my colleague, Mr. Hillier, has a vacation notice on file. He's already submitted it. He's leaving on Saturday morning. The tickets are non-refundable." The judge leaned forward. "So, he left to go on vacation," she said coldly. "And so that the record can be clear, this was the date the parties chose." The courtroom murmured. The tension was palpable. At the defense table sat Jasmine, a young associate barely 2 years into her career, clutching her notes tightly. Next to her, Jason Goss, a seasoned attorney, stood ready to step in for his absent co-counsel. But the judge wasn't done. "Mr. Hilliard is not present. As you can see, he's not in the courtroom. The person now at this table is an attorney by the name of Jason Goss. Please stand." Jason stood tall, the weight of the entire defense pressing on his shoulders. In a single clip, later shown as evidence, Judge Boyd grilled him for nearly 9 minutes. She questioned his presence, his role, even his credibility before the jury. Then she brought in the jurors and asked if they recognized him, forcing a scene that felt more like humiliation than procedure. To Jason, it was deliberate. To the defense team, it was demeaning. But the trial went on. The case dated back to 2022, to a crash at 281 and TPC Parkway. The defendant, Alexander Castro, stood accused of manslaughter. He had been driving over 90 miles an hour after buying drinks at several bars. The police claimed alcohol was involved. The defense insisted it was traffic caused by a previous accident. If convicted, Castro could face up to 20 years in prison. In the hearing, the state and defense battled over the details. Every word mattered. The question wasn't just whether alcohol was consumed, but how the word impaired should be used in front of a jury. The prosecutor spoke first. "Judge, we are not saying the defendant was intoxicated. He's charged with manslaughter, not intoxication manslaughter. We simply want to establish that he consumed alcohol before driving. That's it." The defense objected. "Your Honor, the problem is that the term impaired is not a legal word. It's confusing to a jury. It carries the same weight as intoxicated, and it's not defined in the penal code. We cannot ask the jury to make a factual determination based on a word that has no legal definition." Judge Boyd tapped her pen. "So you're saying the word is confusing?" "Yes, Your Honor," the defense replied. "A layperson hears impaired and immediately thinks drunk. It's misleading." The judge leaned back in her chair. "But isn't that something you can handle through cross-examination?" The defense hesitated. "Perhaps, Your Honor. But it risks prejudice." "Noted," she said. "Then before the jury hears any testimony suggesting impairment, I'll have the witness questioned privately. I'll decide then what's admissible." The courtroom breathed again. But the pressure hadn't lifted. Moments later, the argument shifted to whether the state could mention the defendant's alleged consumption of alcohol at all. "It's in the indictment," the prosecutor insisted. "He admitted to drinking. That's part of the record." The defense fired back. "Case law says that consumption of alcohol by itself is not illegal. To allege it as a factor of recklessness misleads the jury." Judge Boyd sighed. "Then when that evidence comes up, you'll both approach the bench. I'll make my ruling then. But the state may mention that alcohol was consumed, not that the defendant was intoxicated." The gavel struck lightly. Motion denied. The defense sat down, visibly frustrated. The next issue, prior convictions, the state agreed they would not mention any unless the defendant testified. The judge nodded. "If you want to bring them up, approach first." Extraneous offenses? Same ruling. Approach before mention. It was a tense chess match. every move carefully calculated, but the next motion raised the stakes. The state requested to bring the actual vehicles involved in the crash for the jury to view outside the courtroom. The defense objected immediately. Your Honor, this would be an improper demonstration. Those cars have been sitting in the SAPD impound lot for 2 years, exposed to weather, corrosion, and decay. Bringing them here would misrepresent the actual condition of the crash. It's prejudicial. The prosecutor countered calmly. Judge, we're not recreating the accident scene. We only want the jury to see the vehicles themselves, the damage, the size, the force. Photographs can't show scale. Perspective matters. The defense argued again. But people know how big a trucker car is, Judge. This isn't necessary. It's designed for shock value, to influence emotion, not reason. The courtroom fell silent again. Judge Boyd adjusted her glasses. I understand both sides. Before I rule, I want the vehicles brought here. I'll see them myself before deciding. She paused. The cars will not remain outside for long, and officers will guard them. Once I see their condition, I'll determine whether the jury may view them. The defense slumped slightly. The ruling was not in their favor, but it wasn't final either. The clock ticked. Another issue emerged. Timing. Judge, the defense said, Mr. Hillier filed his vacation notice 2 weeks ago. He's leaving on Saturday morning. The court knew this schedule when setting the date. We're simply asking for a continuance until he returns. The judge shook her head. No, my salary is paid by the taxpayers. This case will be done before Saturday. But, Your Honor, the defense persisted, we have hours of body cam footage, witnesses, and evidence. We'll be rushing justice just to beat the clock. The judge raised her voice slightly. We will not rush justice. We will finish efficiently. If we must stay late, we stay late. If we must come Saturday, we will. But this case will not drag on. She smiled faintly. And for the record, Mr. Hillier, if you miss your cruise, maybe I'm saving your life. I've heard terrible things about cruises. A ripple of laughter broke through the tension. Even Jason cracked a faint smile. But deep down, he knew the case had become personal. Every motion felt like a battle, every ruling, a wound. As the session ended, the judge's gavel echoed through the chamber. We'll reconvene at 1:30 for jury selection. Everyone be ready. No delays. Jason looked at Jasmine. Her face was pale, but determined. They had only a few hours to prepare for the fight of their careers. The storm in courtroom 187 had only begun. The courtroom buzzed with restless energy as Judge Boyd entered, her presence commanding instant silence. She glanced over the crowded room and spoke sharply. My salary is paid by the taxpayers, and guess what? If we need to be here on Saturday, I know nobody has anything to do. I'll be here on Saturday. So, we're going to get it done. The lawyers froze in place. Defense attorney Jason Goss straightened his tie, trying to stay composed. Judge, he said carefully, my co-counsel, Mr. Hillier, has a vacation notice on file. He's leaving Saturday morning with non-refundable tickets. The judge's reply was blunt. So he left to go on vacation. Let the record reflect that this date was chosen by both parties. Her tone echoed through the courtroom, cold and final. Jason exhaled slowly, realizing the storm ahead. He stood as instructed, his name called out for the record. The judge's next command cut deeper. Does anyone recognize this attorney? The jurors looked around but remained silent. To Jason, the question wasn't about identification, it was about humiliation. The trial hadn't even begun, and the atmosphere was already poisoned. The case itself was grim. In 2022, a collision at 281 and TPC Parkway had claimed a life. The accused, Alexander Castro, was said to be driving over 90 miles per hour after drinking at several bars. Police claimed alcohol was a factor. The defense argued traffic congestion caused by another accident was to blame. If found guilty, Castro faced 20 years in prison. Every detail mattered, even single words. When the prosecutor argued, "We're not saying the defendant was intoxicated, just that he consumed alcohol," Jason stood immediately. "Your Honor, the term impaired is not a legal term. It confuses a jury. It's synonymous with intoxicated but undefined in law." The judge raised an eyebrow. "Can't you handle that on cross-examination?" "Maybe, Your Honor," Jason said, "but once the word is spoken, the damage is done." She nodded slightly. "Before any witness testifies about impairment, we'll question them privately. Then I'll decide." Minutes later came another clash, whether the jury could even hear about Castro drinking.